Okay. Hi, everybody. You are very welcome along today for our lunchtime talk with Ballymun Community Law Centre. Um, Thank you for joining us. Ballymun Community Law Centre is a charity and an independent law centre. We've been in Ballymun for 21 years. Our mission is to empower the community of Ballymun to exercise their rights and achieve social justice. So we do this through providing legal advice, information, advocacy, representation, legal education and training, and we have an alternative dispute resolution service as well. So we provide mediation in the community, peer mediation training in schools, we train mediators, and we have a conflict coaching service. Um, we're very proud to be part of the recently formed Ballymun for All coalition, and we believe that as a law centre, we have an important part to play in the community. So we're providing the talk today to offer some clarity on the law that applies to people seeking international protection in Ireland. And we're absolutely delighted to have Cillian Bracken agree to do this with us today. Cillian is a barrister specialising in immigration and asylum law, among other things. And he's a lecturer in constitutional law and judicial review in Griffith College. So before I hand you over to Cillian, I'd just say a couple of things. It is a webinar, so I can't bring anybody in, but if you have questions, we've left a good bit of time at the end to address them. So pop them, rather than in the chat, stick them in the questions and answers. It's a bit more organised to see them in there and for us to take them. So put the questions in the questions and answers and we'll get to them. And then at the end, when we finish the webinar, you'll get a pop-up screen with just 3 short questions, and we'd really appreciate if you could just let us know what you thought, if it's something you're interested in more of, and we'd be grateful for your feedback on that one. And then, as I said at the start, the session is being recorded, so you can share it with colleagues afterwards. So I'll hand you over to Cillian, and thanks everybody for joining us.
Hi everyone, I'm just going to try and share my screen there, and hopefully I hope everyone can see that there now. Does it look like it's coming up?
That's it. We can see your notes there. It's not the full screen. We can see the split screen.
That's sorry, probably an absolute nightmare. How do I change that? I might just leave it on this one, so I suppose it comes as like yeah. So I suppose first of all, thanks to Claire and to Frank for inviting me. I'm delighted to be here. And hopefully I won't bore everyone to tears trying to, I suppose, explain the nuances of the Irish international protection system. So I suppose really what I hope to achieve is that I suppose you'll leave maybe with a slightly better understanding of the various kind of definitions and concepts and how the system works more generally. I'm kind of really just going to do 2 broad things. The first is really explain how the Irish international protection system works. And then I'm also going to explain very briefly then how the system as it applies to Ukrainians, which is a slightly different system, how that works too, kind of just so that you know and you can understand, I suppose, the differences between them. So as I said, a bit of an overview there. So just first of all, the relevant definitions, the system, then things like exclusion and cessation when someone stops being a refugee or is excluded from being a refugee. Other kind of important aspects of the process I'll just hit on: appeals, reception conditions. Then that refers to kind of the accommodation that we provide for asylum seekers whilst they're in Ireland. Just a few common myths and misconceptions about the system, and then finally the temporary protection system, which is the one that relates to nationals of Ukraine. So I just to start really. I suppose the various legal bases for international protection in Ireland. So when I refer to international protection, I'm referring to the process by which someone is determined to be a refugee or entitled to other forms of protection that we have as well, which I'll also explain. So kind of the bedrock of that is the Refugee Convention from 1951 and its 1967 protocol. So that's also referred to as the Geneva Convention, one of the Geneva Conventions. So effectively, the Refugee Convention kind of arose out of the Second World War and the huge movements of people that were displaced by the Second World War. And obviously, whilst asylum was before that a concept, there was really an attempt to try and regularize it into a particular system and kind of have one overarching international treaty. So the original Refugee Convention was actually temporarily limited. By that, I mean it was only for people who were looking for protection up until the early 1950s, and also only applied to Europeans. But then the 1967 protocol then changed that to remove that temporal limit and also get rid of that geographical limit. Now, international protection in Ireland is part of European Union law. So there's a qualification directive that basically sets out the minimum kind of criteria for determining if someone is entitled to protection, and then the procedures directive that relates to how we go about that. And we've transposed that, so we've brought that into Irish law via this one act, this International Protection Act 2015. Now, there are other regulations as well, which I'll hit on as we go through, but the International Protection Act is the main act. So prior to that point, prior to the coming into force of that act at the beginning of 2016, the old system was dealt with under the Refugee Act 1996, but there was also separate systems too in relation to other forms of protection. And this 2015 Act brought it all into one place to create, I think, an important thing to understand really is the distinction between, say, an asylum seeker as well as a refugee. So when we refer to an asylum seeker, what we refer to is a person who has left their home country in order to seek protection. So that is a person who has not yet been recognized or declared a refugee. Rather, it's a person who is or who has fled their country of origin and is intending to or has applied for protection. So I suppose in legal terms, we refer to asylum seekers as applicants for international protection, but I suppose an asylum seeker is not the same thing as a refugee. So what then is a refugee? So this seems like a very dense and very long definition, but I suppose you can break it down a small bit. And this comes from Article 1A of the Refugee Convention, and it's also been brought into Irish law through the 2015 Act. But it says that it's a person who, owing to a well-founded fear of being persecuted, so that person obviously has a fear of an adverse situation, for reasons of their race, religion, nationality, political opinion, or membership of a particular social group, is outside his or her country of nationality and is unable, or owing to such fear, is unwilling to avail himself or herself of the protection of that country. Now, there's other things to do with statelessness there as well, but I'm not going to touch on those. But I suppose in essence, you need to have one of these 5 specific reasons why you are being persecuted in your home country, and you then present at the border of another country looking for protection because you're not able to get it in your country of origin. Okay, that's essentially what it is. So when we think about a refugee, I suppose the important thing to remember is that it's really an individualized form of protection. So it has to arise where the person has a well-founded fear. So that's a fear that they obviously subjectively have a fear, but there's objective reasons for recognizing that it exists, that they're being persecuted. So obviously they're suffering some sort of ill consequence or ill treatment in their home country. And it has to be for reasons of race or religion or nationality or political opinion or membership of a particular social group. So if we think, for example, about maybe Ukrainians, they might fall within nationality, for example, or political opinion. If we think about Syrians who were against the Assad regime, they might fall within political opinion. If we think about Afghanis who are opposed to the Taliban, they might fall within political opinion as well. But there are basically 5 reasons there why, on the basis of which you can apply for refugee status. Now, membership of a particular social group is kind of it refers to kind of perhaps something that isn't caught by those other 4 convention grounds. And it typically refers to you being a member of kind of a somewhat recognizable or cognizable homogenous group. So usually, for example, a good example would be if you're maybe gay and you live in a country where it's illegal to be gay and that you might be subjected to the death penalty or individual persecution because of that. Gender is also a particular social group. So for example, if we were to use the example of Afghanis in Afghanistan as well, obviously the Taliban in particular have stopped women and girls from availing of particular education or access to education and are persecuted on that basis. So they might fall within that as well. But I suppose a refugee has a particular individualized reason for seeking protection on one of these convention grounds. Now, as well as that, we also have this other form of protection referred to as subsidiary protection. So this is a form of complementary protection. So it's someone who doesn't fall within the definition of refugee, but falls within this broader definition and should be given protection for that reason. So we define that as a person in respect of whom substantial grounds have been shown for believing that he or she, if returned to their country of origin, would face a real risk of suffering serious harm, and who was unable or owing to such risk, unwilling to avail himself or herself of the protection of that country. So serious harm then is defined in those terms: A, B, and C: death penalty or execution, torture or inhuman or degrading treatment, serious and individual threat to a civilian's life by reasons of indiscriminate violence in a situation of international or internal armed conflict. So it's a broader understanding of protection. It's not based on one of the 5 convention grounds. Typically, we would often see this in situations relating to C there. So indiscriminate violence in a situation of international or internal armed conflict. So for example, if we think about Syrians or Ukrainians, they might be simply civilians. They might not have a particular specific individualized reason why they would be able to be recognized as a refugee, but they do live perhaps in a large war-torn war in the midst of an internal or an international armed conflict, which is why they're given protection. So it's a different form of protection, one that is slightly broader. Finally, then, we also in Irish law have what's known as humanitarian permission to remain. It's also referred to as leave to remain. So this is kind of a slightly broader form of protection, or it's not really, I suppose it's quasi-protection really. So it's up to the Minister for Justice in their discretion to determine if you fall within this based on these factors. So the nature of the person's connection with the state, if any, humanitarian considerations. So for example, that could be to do with specific health reasons, the character and conduct of the applicant, both within and where relevant and ascertainable outside the state, including criminal conviction. So, you know, what sort of stuff they've been up to in the state, what sort of stuff they've been up to outside of the state, whether in particular, you know, there is, you know, maybe there could be a good community involvement. This falls in within A as well, and whether or not their character is affected by that. D, considerations of national security and public order, and E, any other considerations of the common good. So I suppose the minister is kind of deciding if someone isn't entitled to refugee status and isn't entitled to subsidiary protection, is there another reason why they should be allowed to remain here? That could be to do with their family connections to the state. That could be because they've kind of contributed a lot to the state whilst they've been here for the purpose of their application. Or there could be a particular humanitarian reasons that they can't return because of what's going on in their home country, or there might be a particular medical reason. So the process then, just to run through the process. So in essence, what typically happens if you're an asylum seeker and you want to apply for international protection, you have to apply. There's a formal application process. You apply under Section 15 of the Act, and you do so typically at the border. So the border includes both, for example, at Dublin Airport. It also includes the Office of the International Protection Office on Mount Street in Dublin. When you apply, usually then you have what's called a Section 13 interview. This is kind of a quick interview that kind of you have an opportunity to set out why it is that you're looking for protection. Now, it used to be that the Section 15 application and the Section 13 interview were done on one day, and then you would be sent out the questionnaire in the post, or you'd be given the questionnaire and you'd be given an opportunity to go off and fill it out, and then you would send it back. Now, that has changed since November. So instead of that, you're supposed to also fill out the questionnaire on the same day that you apply. And you're supposed to do so in English with the aid of what are called cultural mediators at the Office of the International Protection Office. Now, there's a lot of criticisms about that system. There's critiques about whether or not that's fair, particularly obviously where a lot of applicants for international protection might not speak English. There's questions about whether or not the cultural mediators are qualified or sufficiently qualified to aid that. But that is currently how it exists. Then after that, you'll be scheduled for what's known as a Section 3512 interview. So that means that you'll come back to the Office of the International Protection Office and you're interviewed then formally by an international protection officer or a panel member of the International Protection Office. So that is effectively the main method by which the state determines if someone is entitled to international protection. So you'll be asked questions about why you're seeking international protection, certain things about your country of origin might be put to you. So for example, if you say, oh, well, I was suffering issues because of this thing, they might say, well, you know, we've looked at this online, we've looked at the various reports of like NGOs or media reports, and it doesn't seem as if that's an issue, things like that. But effectively, it's an interview, usually lasts a number of hours, where the reasons for why someone is applying for international protection are thrashed out. Following that, then the International Protection Office compiles what's called a Section 39 report. So that's the decision in relation to whether or not someone is entitled to refugee status or subsidiary protection, whether or not they're going to be granted it or refused it. As well as that, then separately, there's also what's called a Section 49 decision. So that's where the minister separately decides if they haven't been successful in getting refugee status or subsidiary protection, if they should be given humanitarian permission to remain. So while someone has or is in the process of applying for international protection, they are permitted to stay in Ireland for the currency of that application. They're provided what's called a temporary residence card. And then children, if you have minor children, those are included with the adult applicants for the purposes of the application. So determining the application then is dependent on a number of things. So I suppose the process by which the International Protection Office determines if someone is entitled to refugee status or subsidiary protection, that kind of depends on a number of things. So obviously, kind of the first thing that they typically determine is whether or not the person is the nationality of the country they say they're from. Are they happy that this person is from Syria or is from whatever other country? Then they will attempt to determine if what the application is, if that's credible, if the person is credible in relation to what they're saying. So if the person is saying, well, these are the reasons why I need protection from this country, the International Protection Office will attempt to analyze their account on the basis of their personal credibility. So for example, is what they've said consistent with what they said in the questionnaire and at the Section 13 interview? Is it coherent? Are they being vague? Do they have sufficient detail? They'd also see if maybe there's other documents that have been provided by these people that would corroborate, for example, why they've applied for international protection. So, for example, if you're saying that you've been persecuted on the basis of your political opinion because you're a member of an opposition party in a different country, are you able to demonstrate that you are a member? Do you have documents to show that? They'll also look at it with regard to what's called country of origin information. So these are reports that are compiled by NGOs like Amnesty International or Human Rights Watch, as well as certain countries also compile country of origin information. The US State Department does it. The UK Home Office does it as well, basically setting out, I suppose, information in relation to particular things in those countries that typically relate to persecution in those countries, and whether or not what the individual person is saying accords with that as well. They also attempt to determine if the person's fear is well-founded. So even if they were to accept everything that the person has said, they still have to determine if it's objectively well-founded as well as subjectively well-founded. So, have they suffered past harm? Is there a risk that they will suffer future harm? And again, this is done with regard to country of origin information. Have they suffered persecution? So are the things that they're saying happen to them, does that in itself amount to persecution? They'll also see if state protection is available. So that means that if they were to return to their home country, would it be possible for them to avail of the help of maybe the police force in that country to deal with their issue, or other state authorities? And then they also determine whether or not that person could internally relocate. So that means that, perhaps someone might have, a particular convention ground. They might have shown that they're credible. They might have shown that their fear is well-founded and that they've suffered persecution, but it could only be in one specific area within that country. And if they were to move elsewhere, maybe it would be that they wouldn't suffer that persecution at all. So obviously, if state protection is available, or if internal relocation is available, obviously then they wouldn't be eligible for international protection. Just briefly then, of course, it's also possible as well for someone to cease to be a refugee, even where they're recognized to be a refugee. So cessation can occur if they return to their country of origin, or if they acquire a new nationality, or if the conditions under which they fled no longer apply. And then similarly for subsidiary protection, if the conditions under which they fled no longer apply. So for a refugee, if they were to go back, obviously, if they're saying, well, I have a well-founded fear of persecution in this country, if you were to go back, that could be indicative of the fact that maybe you no longer have a well-founded fear. Exclusion then, so obviously in certain circumstances, even if you meet all of the criteria for being eligible to be a refugee or for being eligible for subsidiary protection, the state still in certain circumstances can exclude you from being a refugee or from availing of subsidiary protection. So this is all set out again within the International Protection Act, but for a refugee, it's where that person has committed a crime against peace, a war crime, a crime against humanity, has committed a serious non-political crime outside the state prior to his or her arrival in the state, has been guilty of acts contrary to the purposes and principles of the United Nations. So that's quite specific. That kind of relates to whether or not they're kind of guilty of what's, I suppose, the crime of aggression in international law. Whether or not there's serious reasons for considering that they incited any of the above. Subsidiary protection then is quite similar, but the grounds are actually lower. So additional to the ones that I've already said, whether or not they've committed a serious crime or whether or not they constitute a danger to the community or to the security of the state. And again, serious reasons for considering whether they've incited the above, or prior to his or her arrival in the state committed a crime not referable to in subsection 1, so the above ones, which, if committed in the state, would be punishable by imprisonment if he or she left his or her country of origin solely in order to avoid sanctions resulting from that crime. So I suppose simply because you meet all the other definitions does not mean that you cannot still be excluded from being a refugee or from subsidiary protection. Now, of course, the entire purpose of the international protection system is to ensure that people don't have to remain in situations where they could be subjected to ill treatment or torture or inhuman or degrading punishment. That's broadly, I suppose, the purpose of the system. So even if someone meets all of the definition of a refugee or meets all of the definition of a person eligible for subsidiary protection, and even if they're then excluded, that is still subject to what's known as the principle of non-refoulement. So the principle of non-refoulement basically is a principle of international law, which says that you can't be sent back to a country where you are at risk of torture or ill treatment or inhuman or degrading punishment. So even if you're excluded and you do meet the definition of refugee, and if there is if you are at risk of being sent back, then you still have to be entitled to remain in Ireland. Now, you would be given a different form of protection or a different form of permission, rather. You wouldn't be able to avail of refugee status. You wouldn't be recognized as a person eligible for subsidiary protection. Rather, you'd have to be given another permission. But that means that you're not able to avail of some of the benefits and rights that refugees and persons from subsidiary protection are able to avail of, which I'll speak about in a moment. So just to briefly touch on, there are some other aspects of the process that are worth being aware of. So when someone applies for international protection, they are fingerprinted. So their fingerprints are taken and then put into a system known as Eurodac, which refers to Eurodactalis, which I suppose whether or not it's a big EU-wide system where all applicants for international protection are fingerprinted, and you're checked to see whether or not you match with anyone who's been fingerprinted before. That can have implications for whether or not your application is accepted in Ireland or not. So, for example, if you'd previously applied for international protection in another country, or if you had been refused there, it could be that you are moved back to that country for the purposes of that application. So if you have been fingerprinted elsewhere, broadly speaking, you often will be moved back under what's known as the Dublin III Convention, or the Dublin III Regulation now, which covers that. So it's a system which applies to the internal, they want to have they kind of want to make sure that originally wanted to make sure that there was a fair system for the distribution of people applying for international protection in the European Union. So if you have applied elsewhere first, you will be moved back there. There's also returns to third and first safe countries. Now that primarily now relates to the United Kingdom. So for example, if someone had spent an appreciable amount of time in the United Kingdom beforehand, before coming to the state to apply for international protection, they can be removed back there too, if the UK agrees to it. And then finally, there's this concept of inadmissibility. So if you've been recognized as a refugee in another EU country, you are not entitled to reapply in Ireland for refugee status. So that often will happen in certain countries where the provision for accommodation or any sort of, services for refugees is very, very poor. In certain countries in the European Union, it can result in homelessness. They just simply don't have access to any services at all, even though they're recognized as refugees and should. So often they'll say, well, why would I stay here? This is terrible, and we'll try and move elsewhere. But there is a system of inadmissibility whereby you can be returned back to that country, or your application will simply be refused on that basis. So if you are refused international protection then by the International Protection Office, you're entitled to an appeal to the International Protection Appeals Tribunal. So this is a full appeal. So you're basically attempting to say, look, these are the reasons again, and you have another opportunity to convince an independent tribunal member that you are entitled to international protection. That's the only appeal that you're entitled to. So there's only one appeal that's allowable. If you are refused by the International Appeals Tribunal, which again undertakes a similar assessment, but in a slightly different way, it's a much more kind of court-focused way, so to speak, than it is in the International Protection Office. So obviously, at first instance, there's a questionnaire and you're interviewed, and then a report. The iPad, and then you attempt to appeal it, but you have to give evidence again. And then there's an opportunity for the International Protection Office through the Minister for Justice to kind of get their side as well and say why they think that the person isn't entitled to refugee status or subsidiary protection. Now, if you're refused by the IPAT, really this can only really go in two ways. One is that you may have recourse to what's known as judicial review. So that's basically certain circumstances where you're able to demonstrate that the decision taken about you by the International Protection Office, or typically more likely the International Protection Appeals Tribunal, has been done unlawfully. So maybe they failed to apply a specific provision of the law that they should have. Maybe there is a fair procedures issue, maybe that they didn't take into consideration. Maybe you submitted a medical report that wasn't taken into consideration, or some of the decision that they've taken is irrational or unreasonable. So that's not the same as an appeal. It's not a full appeal of the facts. That's far, far narrower. It's specific to the lawfulness of the decision. And in order to get judicial review, you need to be given what's called leave to seek judicial review by a High Court judge. So that's permission to bring that case. So the judge will look at your application for judicial review and decide, in relation to decisions of the IPAT and the IPO, if there are substantial grounds that the court should examine the lawfulness or subject to judicial review. Now, if you don't have any grounds and if you're unable to pursue that, then technically is what automatically follows by operation of law, because of the manner in which the provisions of the law are written, is that under Section 50, then you'll be told that you're going to be issued with the deportation order, and that effectively then is the end of the process. Then obviously there's also reception conditions, just to talk about that very briefly. So obviously if you are an applicant for an international protection asylum seeker, depending on your means, then you're typically provided with accommodation, either via direct provision accommodation, which I'm sure most people are aware of, or via emergency accommodation, because obviously the system is kind of, the state is struggling to identify or set up new direct provision centres. And obviously direct provision in itself has been criticised very, very broadly and quite frequently for the conditions. Obviously you're provided with accommodation and food. You're also given a weekly payment. IELTS receive €38.80, I think was the last time I checked. I think these figures are still correct. And then children $29.80. You're permitted to work if your application is still in the process at first instance after 6 months. So you're not allowed to work for the first 6 months of your application, but if you're still awaiting it, you can. Plus you're here because obviously if you're of limited means, you would be entitled to access to medical services. You must pay for third level education. You're not given access to third level education on the same basis as Irish nationals. And you cannot leave the state while the application is still in process unless they also hold another permission at the same time. That's not typical at all, but you can't leave the state without the permission of the minister. So if you are recognised as a refugee or as a person eligible for subsidiary protection, you're referred to as a beneficiary of that status, and you're given a renewable, if you're a refugee, a renewable at least permission of 3 years initially. And then you obviously have access to social welfare, employment, education, and medical care on the same basis as Irish nationals. And obviously, that's obviously dependent on means in certain circumstances. You're also entitled to apply for a form of narrow family reunification within 12 months. So that is that certain categories of family member are entitled to come and join you in the state if you apply within 12 months from being declared a refugee. So, for example, if you have minor unmarried children, you might be able to bring them, or if you have a spouse and that relationship was subsisting prior to your application for international protection, you can have them, or a civil partner as well. A refugee is entitled to apply for naturalization after 3 years from the date of their application. They're entitled to apply for what's called an Irish travel document. Obviously, a refugee wouldn't be an Irish citizen upon their declarations, and they wouldn't be able to avail of a passport of their country of origin. So I suppose they're given what's called a travel document to facilitate them if they need to travel. And of course, they can't return to their country of origin because that obviously could result in cessation. Subsidiary protection is very similar for most of those the above. They can return to the country of origin. It's slightly different because often, for example, if you're recognized to be eligible for subsidiary protection, it could be to do with the fact of a war going on, but obviously maybe in particular circumstances, you might not be affected by that or might have ceased. And then they're entitled to naturalization after 5 years from being recognized as the person eligible for subsidiary protection. Briefly then, just unaccompanied minors. So it can be the case too that children come to the state unaccompanied. So children under the age of 18, they're referred, or if an international protection office, if the international protection office understands or suspects the person to be under 18, then they'll be referred to TUSLA, the Child and Family Agency, and they'll be placed with a foster family whilst their application is to be considered. It's kind of the process for determining age is somewhat unclear. There's questions about whether or not TUSLA have a policy in place to determine that. It's obviously a very, very difficult thing to determine if someone is under 18 or not, where obviously maybe they might be kind of, they could be 16 or 17 or 18 or 19, you know, it can be difficult, but it's kind of a quite a fact-driven and context-driven situation. So then just finally, in relation to international protection, I suppose, I think it's worth maybe just running through some of the, I suppose, the most common myths and misconceptions in relation to applications for international protection. So often, I suppose, people suggest, you know, why is it that, for example, if you're from somewhere that's quite far away, why was it that you didn't just stop or applied for protection in the first country that you got to, the first safe country? So I suppose it's worth stating that something along the lines of, I suppose, 86% of the world's refugees are actually already hosted in countries that are within a certain geographic limit from them. So 69% in neighboring countries, so the immediate country over. 75% of refugees are hosted in low or medium income countries. And then 36% of the world's refugees are hosted in just 5 countries. So in general, the vast majority of people who are recognized as refugees throughout the world are in the country that's immediately, I suppose, next or at least in close proximity to them. But the primary reasons, and probably ones that I think most people would certainly empathize with, the primary reason that people do come perhaps to countries beyond that is, first and foremost, is usually family. So usually they might have some connection with the state, a family member who's already here, and obviously want to join or accompany them in the state. Another reason then, of course, is language. So it could be that they think that if they were to go to a particular country where they speak the language, that they might have, I suppose, be better able to integrate into that country. And obviously related to, I suppose, people showing up without documents or disposing documents. But often, I suppose, because in general it is extremely difficult to get to a country illegally or I suppose, you know, without the appropriate or proper visas, often people are forced into situations where they have to avail of smugglers, or often sometimes they're even trafficked. So you know, it can happen in circumstance where they're told, oh, well, I'm going to bring you to this country and it's going to be great, but it's actually for a more kind of a illicit or disturbing purpose. For example, child trafficking or sex trafficking or forced labor, things like that. So sometimes there is an involuntary aspect to it too. But I suppose generally speaking, you know, a lot of people will have to pay huge amounts of money to avail of the services of smugglers. And so the only way they can do that is to use documents provided by smugglers who either will want it back from them. Often the smugglers will accompany them when they're smuggling them, or they'll have to destroy them because obviously the smuggler won't want that document to have been found by the authorities of that state. Another, I suppose, common myth or misconception is in relation to people coming here illegally. I suppose in circumstances where you come to the state to apply for international protection, that is not illegal. It can't be illegal. So the Refugee Convention in particular precludes, I suppose, the criminalizing of people who have come to a country to apply for international protection. It is prohibited. So I suppose it's kind of almost a misnomer. So I suppose often we hear the term perhaps maybe slightly better, but it's kind of a bit of a strange term where someone will come here irregularly, and that kind of refers to the fact that maybe they don't have a visa to come here, or maybe because of the country they're from, they aren't entitled to come here without a visa. But I suppose if you are coming here for the purposes and do apply for international protection, that is not unlawful. Unvetted then is often something you hear quite frequently. And I suppose in comparison even to, I suppose, most tourists who come here, this is applicants for international protection are vetted quite heavily. So I suppose as I said, they will provide their fingerprints to the Eurodac system, this huge EU-wide system of determining where they've been already. And that can obviously then raise flags as to their conduct in those countries. But also as well, since 2021, Ireland now has opted into what's called SIS2, so the Schengen Information System. And that's kind of an extremely large, huge database, a pan-European database relating to effectively whether or not people have been flagged as having committed crimes in individual member states of the European Union. Finally, then, I suppose it's worth noting as well that of recognized refugees in the world are children. 41% of refugees are children. And I think there's often this myth or misconception that, you know, you have, you know, it's predominantly men or kind of older men, but in reality, that really isn't, that doesn't stack up at all in relation to the actual statistics. And finally, then I'm just going to run through just very, very briefly, because I feel like I've been banging on for ages. Just the system that applies to Ukrainians, that's temporary protection. So this is a different directive. It's a different system that applies to that applies to Ukrainians. So this is the first time, it's a part of European Union law. This is the first time it's being used. So originally, the Commission estimated between 2.5 and 6.5 million people would be displaced. But that, you know, we're already far beyond that. Temporary protection there is kind of determined as kind of this procedure of exceptional character when there's potentially going to be a mass influx of displaced people from another country. So I suppose the purpose of the directive, this temporary protection directive, was kind of because obviously if you apply for international protection, that involves an individualized assessment of whether or not you're entitled to protection or not. That system really doesn't work if you have a lot of people looking for protection at the same time, as would have been the case with the Ukrainians this time last year. So obviously in countries that bordered Ukraine, like Poland, large number of Ukrainians obviously fled Ukraine, and their system just simply would not have been, and all European Union-wide systems would not have been able to deal with the number of people who were fleeing because obviously of the violence that was happening. And then it defines what a displaced person is there, kind of very similar, reasonably similar kind of considerations to refugee status and subsidiary protections. But in general, it's that persons who have fled areas of armed conflict or endemic violence are persons at risk of or who have been the victims of generalized violations of their human rights. So I suppose it's a system that's built to deal with large amounts of people fleeing a country, typically because of an armed conflict. So the temporary protection directive then is kind of limited. I suppose it's worth noting that it doesn't relate to all Ukrainians. All Ukrainians are not able to avail of it. Rather, it's Ukrainian nationals residing in Ukraine before the 24th of February, stateless persons and nationals of third countries other than Ukraine who benefited from international protection before the 24th of February 2022, and then the family members of those people too. So in general, the scope of it is that it's supposed to last initially for 1 year, and then it extends for 2 periods of 6 months automatically. So that's another year basically. And then it can also be extended by 1 final year by what's called quality majority voting by the Council of the European Union. So in general, I suppose the time limit is typically 3 years. If after so in 2 years' time, if the conditions still prevail and if the European Union still wants to provide temporary protection, they'll have to kind of start the process all over again. So this is just a small bit then about the content. So as the content of the directive gives kind of, I suppose, immediately access to material conditions that kind of go beyond what an applicant for international protection or asylum seeker would get. So they can have access to employment and self-employment immediately, as well as adult education, obviously access to residence visa permits and visas. They have to be provided with access to suitable housing, or at least the means to obtain housing. To receive necessary assistance in terms of social welfare and the means of assistance if they do not have sufficient resources. Obviously then access to being employed or self-employed. And then of course, medical assistance, particularly for those either with special needs or those who have undergone torture, rape, or other serious forms of psychological, physical, or sexual violence. As well as that, then education for children, obviously, of course, they have rights of family reunification, which is kind of actually already incorporated within the scope, kind of both a narrow and a broad form of family reunification. Article 16 then just addresses unaccompanied minors. And then Articles 17 and 19 set out how the temporary protection system interacts with the international protection system. Then, of course, as well, you could also be excluded from temporary protection if there's serious reasons for considering that you've committed a crime against peace, a war crime, a crime against humanity, a serious non-political crime, or guilty of acts contrary to principles and purposes of the UN, or there's reasonable grounds for regarding you as a danger to security, or if you're convicted of particularly serious crime and it's danger to community. So I suppose overall, really, the system as it applies under temporary protection is just a broader one. It allows access to supports basically immediately. For applicants for international protection, they get access to some supports, but really not on the same basis until they are actually recognized as people entitled to international protection. So the system is quite different in those respects. So obviously you might have seen in the news that there's comment about the differences in treatment between applicants for international protection and those who enjoy temporary protection. But I suppose part of the reason is because the European Union has chosen to avail of this legal basis because of the huge number of people coming in, and this just provides a more favorable approach. So thank you. I hope that wasn't a bit too dense. I felt like I was kind of running through it there. That was obviously that was kind of a crash course in the international protection system and the temporary protection system, but thank you for listening too.
Thanks, Cillian. No, that was brilliant. You definitely took us through it. So thank you so much for that clear and informative walk through the process. And I know it's hard to talk for so long on your own with no feedback from us, but I think most of us are hanging on your words there. So if anyone wants to pop any more questions into the chat, now is your chance. We'll take the 1 or 2 that are there, and then we'll wrap up. So pop them in if you have a question there. So we just have one about judicial reviews. So you mentioned that people have to apply for the judicial review. Are the reviews normally granted when they're applied for, and do many people request a judicial review?
So I suppose the thing about judicial review is that it's a court process. You're challenging the lawfulness of a decision. I would say in general that judicial review probably isn't successful because obviously the standard is quite high. And effectively, the decision kind of enjoys a presumption that it's valid. So really, all of the burden is on the individual applicant to show, well, the International Protection Appeals Tribunal or the IPO did X unlawfully or did Y unlawfully, or this was unfair. It's entirely on the applicant. So it really isn't the case that it's kind of an easy one to get over. But I think in general, if it does go to hearing, if it does get heard before a judge, ultimately, the chances of success probably aren't great. You are up against it, so to speak.
Yeah. Okay. Thanks. Another question there, just about the time. So, on average, how long does the vetting and consideration of an application take?
So I suppose the vetting kind of happens immediately, I suppose, once a person applies, but the application process, I suppose it's fluctuated hugely over the years. So it previously was the case that from start to finish, it would take years and years almost. But now I suppose there was a lot of criticisms of the Department of Justice and the International Protection Office, and that has changed a lot recently. I certainly personally, and this is obviously only anecdotally, have seen that it has been a lot faster even in the last 6 months. And obviously I think there is more of an emphasis on getting these things decided. So, often previously before, maybe in total it could be 18 months, but they do seem to be getting it done now. They seem to be coming on, getting the initial decision and coming on for appeal all within 6 months now. It seems very fast.
Thanks. Another question in the chat, an interesting one. What is the status of babies born to applicants?
Yeah, so that's a slightly difficult one. In general, technically speaking, there's differing opinions on whether or not a baby born to an applicant whilst they're an applicant would automatically just become part of their application for international protection. But what typically happens is that depending on the part of the process that you're in, they might typically kind of put in a similar application. But in general, because obviously a baby can't be interviewed or a baby can't appeal, it's all decided at the same time. So I suppose it's more of a technical question about what point or whether or not they need to do a separate application. But in general, because the baby's application is the parents anyway, it's all decided on that.
Yeah. Somebody else is asking, do you have any thoughts on the changes to being made to the questionnaire thing that you mentioned to us?
Yeah, I mean, I would be pretty skeptical about the changes. I think that in many respects, it's preferable to do this properly, even if it involves maybe slightly more administration than it is to try and rush it. I suppose, often the purpose of the questionnaire and then the interview is obviously so that the department and the International Protection Office have an opportunity to see, okay, are they being consistent? Are there, is this coherent and things like that? Whereas if someone is kind of rushed, or if someone isn't able to fully understand the questions, or if there's no one who's present who can help them with the language, then this just, I think, typically will compound delays and create things further down. So whilst the rationale is to try and use this to speed it up, I don't think this is really the best way to go about it.
And you mentioned in that scenario that I can't remember the term you used, Cillian. It wasn't translators. The
cultural mediator. Yeah.
Yeah. Are those translators? Or?
I think there are. So for example, for countries which there kind of can be more arrivals than others, you're probably likely to have someone who is both a cultural mediator and an interpreter. So for the more common languages that the International Protection Office would come across, but in general, I think they're kind of almost just people who are there just to help. It's all vague, yeah.
Another question, and that might be the end of them then. You mentioned about countries becoming safe. So somebody is asking, does that ever happen that somebody is returned to a country that's become safe after the status is granted?
So typically no, and I suppose, I suppose Ireland doesn't have an approach where it kind of like looks back over and reviews to see, oh, well, this person said, they were from this war-torn. Correct one, because
sorry, Cillian, your sound just blipped for a second there. Would you mind just giving us the last couple of seconds again? Sorry.
I suppose the approach that's taken is to not do that, and I think the rationale is because obviously, if people are constantly in fear of just being returned back, it's really going to undermine their ability to integrate into Ireland. It's really going to undermine their kind of connections with the state. So I suppose I think the approach that's taken is to really not do that unless, in particular instances, a particular person has done something worthy of returning them. But in general, no. And I think the reason for that is because it is a bit self-defeating, I suppose.
Thank you very much. The final question there is about the slides. Will the slides be circulated?
Of course, yeah. No, I don't mind at all. I can send them on to you.
Oh yeah. Okay, thanks. I can send them to people who are registered. Do you want to add any final words, Cillian?
No, not at all. No, I just hope that it was a small bit illuminating and that people kind of now feel as if they have a better understanding than they did coming into it. That's all.
Well, I can tell you, everybody who joined stayed with us for the time, and I think it was really clear and really informative for all of us. So thank you so much. Really, really appreciate it. Thanks to everybody who joined us today. We do have a few comments in there. Give me some feedback. It was excellent. Thank you very much. Says someone. So there you go. Thanks to everybody who joined us. Much appreciated. And as you log off, as I mentioned, if you could answer those few little questions for us, we'd appreciate it. So thanks, Cillian. Thanks to everyone who joined us. And that's it. Take care.
Thanks, man. Bye now.
Bye now.